Good morning. Are you Michael Anthony Newsome appearing there from the jail?
Yes, sir.
All right. This is case number 24 CR 15, State of Ohio versus Michael Anthony Newsome. The Assistant Prosecuting Attorney is here representing the state. Mr. Newsome, you were indicted by the grand jury on Tuesday on a charge of failure to comply with the order signaled a police officer, a third-degree felony. Now, the indictment alleges that on or about January 18 of this year, that you in Highland County operated a motor vehicle to willfully elude or flee a police officer after you received a signal to stop, and that the operation caused a substantial risk of serious physical harm to persons or property. Now, that is a third-degree felony. Third-degree felonies carry a possible prison term of between 9 and 36 months in the levels provided by law, and a fine of $10,000. There's also a possible, or a mandatory license suspension of 3 years to life. Now, you're entitled to have an attorney to represent you, and if you cannot afford to hire one, the court will appoint one for you. And I see you have filled out a financial disclosure form. Is everything on this form correct?
Yes, sir.
All right. When's the last time you were employed?
It was, I don't know, about 3 years ago.
All right.
I got back problems.
Okay. Then the court will find that you're indigent and unable to afford your own counsel. The court appoints Attorney William Armentrout of Hillsborough, Ohio, to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. Bond will be set in the amount of $10,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony. And if convicted and sentenced on that, no matter what happens in this case, be under pretrial supervision of the probation department at 117 East Main Street. Report to them immediately upon release. Must report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. Any treatments indicated, you'll enroll in and follow that during the period of this action. You'll also be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. You can attend any kind of educational programming, job training, college classes, etc. You may also attend meetings with an attorney or probation officer or court proceedings in this or any other case. You can also go to church services. Other than that, you have to be there at all times. If you fail to comply with those conditions, then the court could revoke that bond and have you held until further order of the court. Now, we'll set a bond review hearing in your case by Zoom. That'll be, I did check the calendar Tuesday. Do you remember what we got Tuesday? We just have just a couple of things. Well, while we're waiting on that, I think it's going to be Tuesday, but the first pretrial in your case will be set for March the 13th at 1:30 p.m. I'm sorry, not 1:30 p.m. Final pretrial will be set for April the 3rd at 1 o'clock p.m. All right. And your trial date, let's see. Trial date will be April the 8th. I'm sorry. I might have misread something here. April the 16th is the deadline. April the 11th will be the deadline. I know that the final pretrial is within the 14 days, but given the speedy trial time, we'll have to make that work. And then the bail review will be Tuesday, March the 12th. I'm sorry, yeah, March 12th. Well, actually, I'll tell you what, we'll just do the bail review at the pretrial. That'll be easier. So that'll be on Tuesday, so we'll do that then, all right. So it'll also be on the 13th at 8, all right. 1:30. All right. All right, we'll notify your attorney of his appointment, Mr. Newsome. He'll be in touch with you. All right, thank you. All right, this is case number 24-CR-43, State of Ohio versus Whan James Stratton. Are you Whan James Stratton?
No, I am, sir.
All right, Mr. Stratton was indicted by the grand jury on Tuesday on 5 counts of rape. The state is represented by Assistant Prosecuting Attorney King. And Mr. King, have the alleged victim or victims or representatives of these charges been notified of the time, place, and purpose of this hearing, the right to be heard in a matter of bond?
Yes, Your Honor. The representative has been notified and has elected not to attend the hearing today.
All right, Mr. Stratton, you are charged with 5 counts of rape. The first 3 are under 290702A1B, and they allege that on or about October 20, 2021, continuing through October 19, 2020, and count 1. Well, let me back up. The first count says that on or about October 2019 through October 19, 2020 in this county, you engaged in sexual conduct with a V whose birth date was 10/20/09, who was not your spouse, and was less than 13 years of age at the time. Count 2 alleges the same offense, except that it occurred October 20, 2020 through October 19, 2021, otherwise the same thing. And then count 3 alleges the same offense that occurred allegedly October 2021 through October 2022. Each of those are first-degree felonies. Count 4 and 5 are under subsection B2, I'm sorry, A2, and they allege on or about October 2022 and count 4 through October 19, 2023, you engage in sexual conduct with V, purposely compelled V to submit by force or threat of force. And then count 5 alleges the same thing occurred between October 20 and November 23, 2023 in this county. All of these are alleged in this county. Actually, counts 4 and 5 do not allege that, Mr. King. there's no allegation of venue. In any event, those are also first-degree felonies. First-degree felonies carry let's see, in this case, what is the sentence? Is this just straight F1 or is it the special?
4 and 5 are straight F1, Your Honor.
Okay, but 1, 2, and 3 are
10 to life.
10 to life, okay. So those are 10 to life, and 4 and 5 are first-degree felonies that are 3 to 11 years, with an additional 50% to be added by the DRC. Each of them carry a possible fine of $20,000 and a designation as a sex offender that would be required to be registered for life. Now, you are entitled to have an attorney. If you can't afford to hire an attorney, the court will appoint one for you. And I see that you have filled out a financial disclosure form. Is everything on this form correct?
As far as I know, yes.
All right. All right, the court will find then that you're not able to hire your own counsel, and the court will appoint Attorney Jeffrey Blosser of Chillicothe, Ohio, to represent you and enter a not guilty plea on your behalf. We will set a bail review hearing for set it for Monday, March 11th at 1:45. And that'll be a Zoom hearing. There will be a first pre-trial then set for this case on March the 18th. That's a Monday. I'm going to have to use some different dates here, Mr. King, because of the timing and the court schedule. And that'll be at 10 o'clock a.m. The final pre-trial will be March the 26th. No, wait a minute. No, we don't want to do it then. April the 3rd. At 1 o'clock. And then trial will be set April the 15th at 8 a.m. Now, state wish to be heard on bond. And,
Only was contained in the bond recommendation sheet, Your Honor.
all right. The bond will be set in an amount of $100,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. And if convicted and sentenced on that, no matter what happens in this case, you'll be required to pay a service fee deposit of $171 prior to release. If you make bond, you'll be under house arrest at your residence at 131 North Fairfield Road in Leesburg. You'll also be subject to pretrial supervision of the probation department. You'll have to report to them immediately upon your release if you make bond at 117 North East Main Street. You report to them once a week for 4 weeks after that as they determine. To go random drug testing, provide phone numbers for home sale employer, have no contact with alleged victim or any family members. If recommended by probation, you'll be evaluated for mental health and/or substance abuse issues. Any treatments indicated, you enroll in and follow that during the period of this action. And your house arrest means that you're to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend church, and you can go to any kind of job training, educational classes, anything of that nature. All right. You have any questions, Mr. Stratton?
Yeah, you said no contact with family members. Are you talking about like family members like my mom and my sister and stuff? Or just the victims?
The victim's family, the alleged victim's family.
Okay.
That would be the defendant's family also, Your Honor.
Okay. Well, that's the order for now. Okay. All right. Thank you. All right. Christian Kol, please. All right, this is case number 24 CR 044, State of Ohio versus Christian Isaiah Kittrell. Are you Christian Isaiah Kittrell appearing there for the jail?
Yes, Your Honor.
How do you spell your last name?
It is Kittrell.
R-E-L-L.
Yes, sir.
All right, the indictment is misspelled, Mr. King. It's E-R-L-L. So, but I'll refer to him as Mr. Kittrell for now. You can attend to that with a motion to amend.
Yes, sir.
All right, Mr. Kittrell, you were indicted by the grand jury on Tuesday on 2 counts of extortion, both third-degree felonies. See, is this a Tier 1 or Tier 2, Mr. King?
Off the top of my head, I'm not certain, Your Honor.
All right, well, I'm going to give you the high tier. That's the worst case scenario. Tier 1 offenses, third degree, carry a possible sentence of 1 to 5 years. If it's a lower tier, then it's 9 to 36 months. There's also a fine available of up to $10,000. And in this case, you are entitled to have an attorney to represent you. And if you don't have the money to hire one, the court will appoint one for you. And I see you did fill out a financial statement. Is everything on this form correct?
Yes, sir.
All right. And when's the last time you were employed, Mr. Kittrell?
It was early in 2023.
All right. Well, the court then will find that you are entitled to appointed counsel. I'll appoint Attorney Catherine Hapner to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. Let's see, when did I send that other bail review hearing on the last case?
There's one on the 11th and one on the 13th, Monday and Wednesday.
All right, let's, yeah, Mondays, I think she's in courthouse. So we'll set this one for Tuesday. Your bail review hearing then will be Tuesday, March the 12th at, let's see here, who we got here? Two o'clock. And that'll be my Zoom. All right, the first pretrial then will be set for March the 20th. At 1 p.m. Final pretrial will be April the 3rd, 1 p.m. Trial date will be May the 6th at 8 a.m. Mr. King, I neglected to ask at the beginning of the hearing, have the alleged victim or victims of the charges been notified of the time, place, and purpose of this hearing, the right to be heard?
Attempts were made, Your Honor. Multiple phone calls were made to both alleged victims. We're not able to make contact, but messages were left for them.
Okay. All right. Well, that court will find that's reasonable effort to make the notification. All right. Now, anything from the state regarding bond, other than
Only what's in the bond recommendation sheet, Your Honor.
All right. So the court will then set bond in the amount of $15,000 plus your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony and if convicted, sentenced on that. No matter what happens in this case, you'll be under pretrial supervision if you do make bond at Probation Department 117 East Main Street. You're to report to them immediately after court, and then once a week for 3 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, employer, have no contact with the alleged victims. If recommended by probation, you'll be evaluated for substance abuse and mental health issues. If any treatment is indicated, you enroll in and follow that during the period of this action. You'll also be under house arrest at your residence at 125 Reba Drive, Apartment B in Wilmington, Ohio. That means you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointment with an attorney or probation officer in this or any other case. You can also attend any appointments with, attend any church services or any kind of educational programming, job, training, college classes, GED classes, etc. If you fail to comply with those conditions, then the court could revoke that bond and have you held in custody until further order of the court. All right. You have any questions, Mr. Kittrell?
No, sir.
All right. Thank you.
Thank you.
All right. Dylan Rogers, please. Kittrell.
Kittrell's pretrial 3:20, 1 p.m.
And then 4.
4:03, 1 p.m.
And 5-6. Okay. All right, this is case number 24 CR 48, State of Ohio versus Dylan Rogers. Are you Dylan Rogers?
Yes, Your Honor.
All right, Mr. Rogers, you were indicted by the grand jury of this county on Tuesday. Looks like 2 counts of receiving stolen property in counts 1 and 2. And Mr. King, have the alleged victims of these alleged offenses been notified of the time, place, and purpose of this hearing, the right to be heard?
V1 and V2 have been notified and have elected not to attend the hearing today. We weren't able to make contact with V3 this morning. However, a message was left for him.
That was the, and that's the one in count 11? V3?
Yes, Your Honor.
All right, thank you. All right, then there's also, there's a total of 12 offenses charged here, Mr. Rogers. So counts 1 and 2 and 11 are receiving and alleged and on or about the date in the indictment you knowingly received, retained, or disposed of property of another that you knew or had reasonable cause to believe was obtained through the commission of a theft offense. In count 1, it's a Chevrolet Equinox 2020. Count 2, it's a 1998 Honda Civic. And count 11, it is a 1990 Honda CRX. Those 3 counts are 4th-degree felonies, and they carry a possible prison term between 6 and 18 months and a fine of $5,000. Count 3 alleges trafficking in marijuana and alleges that on or about the date in the indictment you only sold or offered to sell marijuana in an amount that was over bulk, over 200 grams, but less than 1,000 grams. And you knew that it was, it's not sale. It's alleging that you prepared for shipment, shipped, transported, or prepared for distribution marijuana in that amount, and that you knew or had reasonable cause to believe it would be intended for sale or resale by yourself or another person. Count 4 alleges on or about the same date you possessed that. Count 5 alleges that on or about July 13th of 2023 in this county, you again, as in count 1, prepared for shipment, shipped, transported, delivered, or distributed, in this case, hashish in solid form, over 50 grams, less than 250 grams, which you knew or had reasonable cause to believe was intended for sale or resale by yourself or another. And then count 6 alleges that on or about that same date, you knowingly possessed that. Now, all of those 4 charges are 3rd-degree felonies, carry a possible prison term of 9 to 36 months, fine of $10,000, and a license suspension of 6 months to 5 years. Now, count 7 alleges on or about July 13 in this county of last year, the same offense, but in this case it would be alprazolam, a Schedule 4 controlled substance over bulk, less than 5 times bulk, that you thought, or that you knew or had reasonable cause to believe would be intended for sale, resale. And in count 8 alleges on or about the same date you possessed that. Those are 4th-degree felonies that carry a possible prison term convicted of 6 to 18 months, also, and a fine of $5,000. Count 5 and 6 were 3rd-degree felonies. Those are 9 to 36 months, $10,000 fine, but also the license suspension. Count 9 alleges that you had a number of items that were subject to forfeiture. Looks like 12 altogether, includes firearms and ammunition and real estate. Count 10 is alleged that you had weapons under disability on or about the 13th of July of last year in this county, and that you were not permitted to have those because you've been previously convicted of possession of heroin in a juvenile court case in 2015, and also in this court in 23 CR 87. And in count 11, I've already told you about, and in count 12 is possession of a fentanyl-related compound, and that alleges on or about the 13th of July in this county, 15th of January, I'm sorry, in this county, you knowingly obtained, possessed, or used fentanyl-related compound. That's a 5th-degree felony, possible sentence of 6 to 12 months, fine of $2,500, and license suspension 6 months to 5 years. All right, you're entitled to have an attorney to represent you in this matter. If you can't afford to hire one, the court will appoint one for you. I believe you filled out a financial disclosure form. Is everything on that form correct?
Yes, Your Honor.
All right, and is this the first time you've been in court on this case?
Yes, Your Honor.
All right. Court will appoint Attorney Jacob Wagner of Hillsborough, Ohio, to represent you. In the absence of counsel, I'll enter a not guilty plea on your behalf. So that's your bail review hearing. Monday, March 11th at 1:30 p.m. Let's see, when were you arrested on this, Mr. Rogers?
Wednesday evening, Your Honor.
All right. Set your first pretrial for April the 3rd at 1 o'clock. Final pretrial will be May the 1st at 1 o'clock. Trial date will be May the 20th at 8 a.m. All right, bond will be set in the amount of $25,000 plus your own recognizance, which is your promise to appear. If you fail to appear, then you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, you'll be under pretrial supervision if you make bond under the probation department at 117 East Main Street. Report to them immediately after court. Report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing, provide phone numbers for home cell employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you enroll in and follow that during the period of this action. You'll also be under house arrest at your residence at 514 McHale Avenue in Greenfield. I mean, you have to be there at all times unless you're working, going to and from work. Medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of educational programming, job training, etc. You can also attend church services. Other than that, you have to be there at all times. If you don't comply, then the court could revoke that bond and you can be held until further order of the court. Have any questions, Mr. Rogers?
No, sir, Your Honor.
All right, thank you. We'll notify your attorney of the appointment and the hearing.
Thank you very much. Are you Caitlyn Rogers? Pardon me? Okay,
It's
there's no
muted.
problem. You're muted there. We'll ask the officer to unmute you. There you go.
Okay.
Thank you.
Sorry.
All right.
Yes, sir.
All right, this is case number 24 CR 49, State of Ohio versus Caitlyn Rogers. Ms. Rogers, you were indicted by the grand jury on Tuesday, along with Dylan Rogers. You were indicted in counts 1 through 9. Counts 1 and 2 alleged in honor about June the 1st, 2023 through July 13th, 2023. You knowingly obtained, possessed, received, retained, or disposed of a 2020 Chevrolet Equinox belonging to another person, knowing or have reasonable cause to believe it had been obtained through the commission of theft offense. Count 2 alleges the same thing, except that it was a 1998 Honda Civic. Then you're charged with trafficking and possession of marijuana in count 3 and 4 on July 13th, 2023, and that alleges that the two of you prepared for shipment in this county on July 13th, 23, prepared for shipment, shipped, transported, prepared for distribution of marijuana in amount over 200 grams, less than 1,000 grams that you knew or reasonable cause to believe was intended for sale or resale by yourself or another. Count 4 alleges on that date you possessed that. Count 5 is trafficking in hashish, and it is the same basically as it's basically preparing for shipment, shipping, or transport and delivering on the 13th of July of last year in this county. Hashish, the same as it was alleged in the marijuana charge. In that case, the value was over 50 grams, less than 250 grams. Count 6 alleges on the same date you possess that amount. Count 7 then also alleges on about last July 13th of last year in this county, the two of you shipped, transported, prepared for distribution alprazolam, Schedule 4 controlled substance, and over bulk, less than 5 times bulk, same allegation as to resale by yourself or another. And then 8 is possession of those drugs. Now, so a total of, the 3rd, 4th, 5th, and 6th counts are 3rd-degree felonies. Counts 1, 2, 7, and 8 are 4th. 4th-degree felonies carry a possible prison term of between 6 and 18 months and fine of $5,000. And 3rd-degree felonies carry a possible prison term between 9 and 36 months and fine of $10,000. And each of them carry a possible license suspension of 6 months to 5 years. Now, you're entitled to have an attorney to represent you. If you don't have the money to hire one, the court will appoint one for you. And I see you have filled out the financial information as form. Is everything on this form correct?
Yes, sir.
When was the last time you were employed?
It was January 11th, and I'm supposed to start a job Monday at FiberTech.
All right. Well, the court then will find that you are entitled to appointed counsel. Appoint attorney Dennis Kirk to represent you. And in the absence of counsel, enter a non-guilty plea on your behalf. And let's see, when did I set the pretrial for, the bail review for Mr. Rogers?
Bail review is 3/11 at 1:30.
All right. So your bond review will be March the 11th, that's Monday at 1:30?
Yes, sir.
All right. And the first pretrial will be April the 3rd at 1 o'clock. Final pretrial will be May the 1st at 1 o'clock. And trial will be May the 20th at 8 a.m. Court will set your bond in the amount of $15,000 plus your own recognizance, which is your promise to appear. If you fail to appear, then you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case, you'll also be under pretrial supervision of the probation department should you make bond. You'll have to report to them immediately upon release. You're required to report to them once a week for 4 weeks after that as they determine. Undergo random drug testing they may order. Provide phone numbers for home, cell, and employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. And if any treatment's indicated, you enroll in and follow that during the pendency of this action. You're not to have any contact with your co-defendant. And if you'll be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work. Medical appointments, court proceedings in this or any other case. May also go to appointments with an attorney or probation officer in this or any other case. And also attend church services and any kind of educational programming, college classes, GED, etc. You listed an address of P.O. Box 258 in Leesburg. What's your physical address there in Leesburg?
211 Railroad Street.
211 Railroad?
Mm-hmm.
All right, so that'll be the place that you'll be required to be except for those exceptions that I mentioned. All right, we'll notify your attorney of his appointment and the hearing on your bail review next week. You have any questions?
Did you say I have a $15,000 bond right now?
$15,000 plus an OR, yes.
Okay,
All right,
okay,
thank you.
thank you.
That's it? That's all the bond reviews?
Yes, Your Honor.
Okay. And then the some attorneys get entered and some don't, so it's a mystery. All right, this is case number 19 CR 131, State of Ohio versus Carl Jalone. This is a hearing being conducted by Zoom. Mr. Jalone is present from the jail. His attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Assistant Prosecutor King. This matter was set for a plea, and I do have a plea of guilty form. Now, before I go to that, Mr. Kirk, do you and your client both agree this matter could be conducted by Zoom rather than an in-person hearing?
Yes, Your Honor.
Is that all right with you, Mr. Jalone?
Yes, Your Honor.
All right, now, if for any reason during the hearing you need to talk to your attorney or ask him any questions, just let me know. I can put you into a breakout room where it'll just be the two of you talking. No one else will be able to see you or hear you, okay?
All right. Thank you, Your Honor.
All right. Mr. Jalone is charged with failure to comply with the order of a signal police officer. And Mr. Jalone, I've been presented with a plea of guilty form. I'm going to hold the first page up to the camera. It has your name and case number and plea of guilty form. You see that?
Yes, Your Honor.
And on page 3, there is a line about not quite halfway down. It says, "I enter this plea voluntarily." Right below that is a signature line. And is that your signature there?
Yes, Your Honor. That's my signature.
When did you sign this, Mr. Jalone? When did you sign it?
Oh, I'm sorry, Your Honor. It was like cutting in and out. It's been about a week and a half or so ago.
Okay. Now, before you signed it, did your I didn't mean for you to come over right now. In about 20, 30 minutes. We're going to two pleas, or plea in the sentencing, as I understand. So, no, I meant to tell her that. That was my mistake. All right.
Your Honor,
Yes.
for some reason, there's a lot of feedback. We're hearing you, but there's some sort of noise in the background
All
on
right. I
somebody's
think I
mic.
know. Let me see if I can fix that.
Yeah, that was the problem.
Yeah,
There
I
we
think
go.
it was Miss West. They had on the mic. All right.
Yeah.
Thank you.
Now, Mr. Jalone, when you signed this, did you understand it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing?
I do, Your Honor.
And did he explain everything to you and answer any questions before he signed it?
Yes, he did a good job, Your Honor.
And it's been about a week and a half, you said. Is this, since you've had a few days to reflect about that or think about it, have you made any change? Have you had any changes of heart, or do you still want to go forward?
No, Your Honor. I prefer to be honest.
Okay. Now, the agreement states that you're going to plead guilty to count 1, failure to comply with the order signal of a police officer under 2921.331B of the Ohio Revised Code, 3rd-degree felony. Further states you understand maximum penalty for that could be between the penalty for that could be between 9 and 36 months. The maximum being 36 months. It would be a fine of $10,000, and there's a mandatory license suspension from 3 years to life. Do you understand that?
Yes, Your Honor.
And also, if you should ever be sentenced to prison for this and another felony, by law, this sentence is required to run consecutively to the other one. Do you understand that?
Yes, Your Honor. I do.
Now, other than this charge, are you facing any felony charges anywhere else?
No, I'm not, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
All right, now, in the event that you're convicted and if you are sentenced to prison upon completion of the prison term, the law provides that you must be placed under post-release control supervision by the adult parole authority for a period of at least 18 months up to a maximum of, 1 year up to a maximum of 3 years. And that means you'll be supervised under the terms that the APA sets by a parole officer, and if during that period of time they determine that you've not complied, they return you to prison, make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for 1 or more violations. However, if you're convicted of a new felony, then in addition to whatever sentence a judge in that new case can impose upon you, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor. I do.
Now, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison or community control sanctions, which means that instead of going to prison, you'd be put under the supervision of a probation officer for a period of up to 5 years under terms set by the court. And if during that period of time, the probation department felt that you were not in compliance, they would file a written notice of that with the court. There would be a hearing, and if the outcome of that hearing was that you failed to comply, then at that time, you could be sentenced to a period of 36 months, fine $10,000. And if your community control were to be terminated because you were convicted of a new felony, then any sentence imposed of that new felony conviction could be served consecutively to this one. Do you understand that?
Yes, Your Honor, I do.
All right, now the charge alleges that on or about June 29, 2019 in this county, and as a continuing course of criminal conduct in Ross County, Ohio, you did operate a motor vehicle as defined in ORC, that's a higher revised code 4501.01, so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop, and the operation of the motor vehicle by the offender causes substantial risk of serious physical harm to persons or property, and violation of section 2921.331B of the higher revised code. So that's the charge with the penalty I described earlier. Do you understand what it is you've been charged with, what the state said you did, when, where, and how they allege you did it?
I do, Your Honor.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible offenses you might try to raise at trial, or possible outcomes of a trial with your attorney?
I have, Your Honor.
Are you satisfied with his advice and confidence in this matter?
More than satisfied, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Has anyone threatened you to make you plead guilty?
No, sir.
Now, on page 2, there are a couple of lines printed in bold and underlined that read, defendant shall enter plea guilty to the indictment. State and defense jointly recommend community control substance abuse treatment. Does anyone promise you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter sentence is up to the judge, Mr. Jalone, so if you plead guilty, I'm not required to follow that recommendation. I could instead impose any prison sentence I think is appropriate between the 9 and 36 months as permitted by law, and I can also fine you as well. And I must, as a matter of law, suspend your driving privileges for at least 3 years. Do you understand that?
I do, Your Honor.
All right. Now, do you hold any type of license or certification from any state governmental agency that regulates any occupation or profession?
I just hold a manager food handler certification from ServSafe. Is really the only certification that I have, sir.
Is that from the Department of Health?
Yes, sir.
Okay. I'm not sure if that's one of the ones that are required, but under the law, the clerk is required to send in a notice to certain regulatory boards, and so of your conviction. And so, if you're convicted and sentenced, then this may be required for that to be sent up. They could take action. Do you understand that?
Yeah, I do, Your Honor. Thank you.
I see here you're trying to enter the waiting room, Ms. Abner. Okay. Oh, okay. All right. Oh, you have the sentencing. I gotcha. No problem then. All right.
Your mic's off, Your Honor.
That's right. I was talking to an attorney in the room. That's why I turned it off.
Sorry.
Listen, you guys didn't want to
sorry
listen to that conversation. So, okay. Now, you have certain constitutional rights you have to understand before it can accept a plea. First of all, you have a right to have an attorney, and Mr. Kirk was appointed to represent you. Now, that appointment wasn't simply to work the case out, but to provide whatever defense might be available to you under the law that you'd like him to provide. So, if you decide that you do not want to do this, he will still be your attorney. He'll represent you, defend you, including a trial, if that is what you want. Do you understand that?
Yes, Your Honor.
Now, under the law, you have you have a right to a jury trial in this matter, in which 12 people be selected from a group of citizens who live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They would be instructed on the law, and then that jury would decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial. That means the judge would be the one who would hear the evidence instead of a jury. The judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine through your attorney. What that means, the witnesses against you have to come into court and testify in front of you, your attorney, and everyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to bring out evidence that would help your side of the case. Do you understand that?
I do, Your Honor.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, same as the state. So if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court issues a court order. It's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
All right, now under the Constitution, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make that decision, and if you decide you do not want to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it during the proceedings except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
All right, now, under the Constitution, you're presumed innocent of the charge until proven guilty by the state of Ohio on every essential element of the offense charged. So, the burden of proof isn't on you to try to prove you're not guilty just simply because you've been accused. In fact, under the law, you don't have to put on any evidence at all. You may, but you're not required to. Whether you put on any evidence at the trial or not, the burden of proof will remain on the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, originally you entered a plea of not guilty. That plea denied the allegation, and the indictment denied you committed any crime and exercised or invoked all the rights I've just described. If you change that plea today from not guilty to guilty, that's the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed that crime, and that plea will waive and give up all the rights I've just described for you, except the right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty would waive and give up your right to a jury or court trial, waive and give up your right to confront witnesses against you and cross-examine through your attorney, waive and give up your right to confront the witnesses against you. Use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. Waive and give up your privilege against self-incrimination because you say you're guilty, that's what's used to find you guilty. It would waive and give up your presumption of innocence because if you say you're guilty, the state is not required to prove you guilty. It subjects you to being sentenced immediately by the court if I think that's the right thing to do. And finally, it waives and gives up the right to file an appeal on any alleged violations of your rights you think you may have had up until this point in the proceeding. Now, should you be sentenced to the maximum sentence or under other limited circumstances, there could be a right to appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, Your Honor, I do.
And are you a U.S. citizen?
I am, Your Honor.
Now, do you have any questions about the charge and the possible penalties?
I do not, sir.
You understand them?
I do.
You have any questions about the plea agreement?
No, Your Honor.
You understand it?
I do clearly, sir.
And again, you understand that the recommendation on sentencing is not binding on the court.
I do, Your Honor.
Do you have any questions about the constitutional rights I've explained to you?
No, sir.
Do you understand those?
I do, sir.
Have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No, Your Honor.
You understand that?
I do.
Now, is there anything you need to talk to your attorney about before we go any further?
No, Your Honor.
All right. Do you have any questions at all about anything I explained here today?
No, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charge pursuant to the terms of this agreement we've just gone over?
Yes, sir.
All right, then, as to the charge, which alleges that on or about June 29, 2019, Highland County, Ohio, and as a continuing course of criminal conduct in Ross County, Ohio, you did operate a motor vehicle as defined in ORC 4501.01, so as willfully to elude or flee a police officer after receiving a visible or audible signal from a police officer to bring the person's motor vehicle to a stop. And the operation of the motor vehicle by the offender caused a substantial risk of serious physical harm to persons or property in violation of Section 2921.331B of the Ohio Revised Code. The charge of failing to comply with the order signal of a police officer, a third-degree felony with the penalties I described earlier. How do you plead?
Guilty, Your Honor.
All right, the court finds on this day in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same. Pursuant to criminal rule 11, the plea is accepted, order filed, defendant is found guilty of the charge. The court orders the matter to be referred to the probation department for a pre-sentence investigation. Under the same bond, that will also include an assessment for substance use disorder, treatment and or mental health. Sentencing will be on April 18th at 2024 at 1 p.m. and bond will be continued. All right, is there anything further from counsel?
No, Your Honor.
All right, then April 18th will be your hearing then. Thank you.
Thank you, Your Honor.
All right. Thompson there at the jail?
Yes, sir.
All right. Oh, wait a minute. That's right. How could I forget that?
Maybe I didn't have it on there.
No, you don't. Now, sorry about that, Mr. Thompson. Now, you are Darnell S. Thompson?
Yes, sir.
All right, this is case number 23 CR 190, State of Ohio versus Darnell S. Thompson. Mr. Thompson is appearing from the jail. This hearing is being conducted by Zoom. Mr. Thompson is indicted, and it looks like a 5-count indictment, and the matter was set today for a plea hearing. I believe we have a trial coming up next week, but due to my schedule, I wasn't able to get this onto the docket until today, and so the court agreed to forego the 14-day policy. Now, Mr. Thompson, I'm going to hold this up to the screen for you. It's a first page of what's entitled a plea of guilty with your name and case number on it. So I'll hold that up to the screen and ask the camera and ask you if you can recognize that.
Yes, sir.
All right, on page 3, there actually at the bottom, the very last sentence reads, I enter this plea voluntarily, and immediately below that appears to be signature Darnell Thompson. And I'll hold that up to this, whoops, a little awkward here. I'll hold, yeah, the way, oh, this is paper clipped, okay, I thought it was, there's a paper clip on it there, that'll work better. All right, now I'm going to hold that up to the camera, and is that your signature down there under the sentence that says, I enter this plea voluntarily by my fingers?
Yes, sir.
All right, when did you sign this, Mr. Thompson?
When did I sign this?
Yes, sir.
I believe Wednesday.
All right. Now, when you signed it, did you understand it's an agreement to plead guilty, which means there's not going to be a trial?
Yes, sir.
And did you go over it with your attorney before you signed it and have him explain things to you and answer any questions?
Yes, sir.
And do you think you had enough time to fully consider the matter?
Yes, sir.
Since it's been a few days since that was signed, have you had any changes that you decided you don't want to do this, or are you still wanting to go forward?
No, sir. Going forward.
All right. And did you enter into this agreement to plead guilty voluntarily?
Yes, sir.
All right. Now, the agreement states on page 1 that you're going to change your plea from not guilty to guilty on count 4. And that is felonious assault under 2903.11A2 of the Ohio Revised Code, a second-degree felony. States that the maximum penalty for that could be 8 years. There's a minimum of 2. Now that refers to the sentence that the judge imposes. Under the law, this type of offense allows the Department of Rehabilitation and Corrections, if they choose to do so, to extend a prison term beyond that ordered by the judge if they have done an evaluation and feel that there should be more time. And so they could make that up to 12 years. If you got an 8-year sentence, they can add up to 50% or 1/2. If you got the minimum sentence of 2, they could make it 3. If it was 4, they can make it 6, and so forth. You understand that?
Yes, sir.
All right. There's also a fine available of up to $15,000. You understand that?
Yes, sir.
And there's a presumption that the court should impose a prison sentence. It's not mandatory, but there is a presumption under the law that that ought to be the sentence. You understand that?
Yes, sir.
And are you facing any felony charges anywhere else?
No, sir.
I'm sorry, let me back up. Mr. King, I forgot to ask. Is alleged victim of this charge been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, he has, Your Honor, and he's elected not to attend the hearing today.
All right, thank you. Also, I neglected to mention, Mr. Armentrout, as you and your client are in agreement the matter can be conducted by Zoom rather than his in-person appearance in the courtroom.
Yeah, Your Honor.
And you're all right with that, Mr. Thompson?
Yes, sir.
All right, thank you. It's been a long week and I'm trying to catch up, so I'm being a little bit fast and getting ahead of myself sometimes. All right, now, are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
And I believe you said you're not on community control, or you're not facing any of the charges except in this court. Is that correct?
Correct.
All right. Now, under the law, if you're sentenced to prison and if you serve the entire prison term, upon completion of that, it's mandatory under the law that you be put under what's called post-release control supervision under the supervision of the Adult Parole Authority for a period of at least 18 months up to 3 years. That means you'll be supervised by a parole officer, and if the parole authority felt that you, or found that you did not comply, then they could return you to prison to serve an additional period of up to 9 months for any single violation, but there is a capital limit of half of the prison term you were sentenced to for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in that new case could impose, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right. Now, under the laws I mentioned, it's not mandatory that I sentence you to prison, although it's presumed. And so you could be given community control or probation for a period of up to 5 years, which means you'll be supervised in a term set by the court by a probation officer. And if during that period of time they felt that you were not compliant, they would file a notice of that with the court, give you a copy. There would be a hearing in which you would have a right to have an attorney. And if the outcome of that was that you failed to comply, then at that time, the court could sentence you to 8 years and fine you $15,000. Do you understand that?
Yes, sir.
I'll also tell you that if your revocation is due to being convicted of a new felony offense while under community control, then under the law, that sentence, if there was one imposed, could be ordered to be served consecutively to the sentence imposed in this case. Do you understand that?
Yes, sir.
Right now, Mr. Thompson, the charge in count 4 alleges that on or about August 16, 2023, continuing through August 17, 2023, in Highland County, Ohio, that you and a Cameron Renner did knowingly cause or attempt to cause serious physical harm to V by means of a deadly weapon or dangerous ordinance, to wit, a Taurus PT 140 40 caliber handgun, in violation of section 2903.11A2. So that's the charge of felonious assault with the penalty I described of 2 to 8 years, plus 50% possible being added on and a $15,000 fine. Mr. Thompson, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, the agreement says on page 3, there's 2.5 lines printed in bold and underlined, and read as follows. Defendant shall enter a plea of guilty to count 4. State will dismiss remaining counts. State and defense jointly recommend 3 years incarceration. State agrees not to object to judicial release after 1 year. Do you understand that?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty?
No, sir.
Now, the matter of sentence is up to the judge as well as a matter of judicial release, Mr. Thompson. And so if you plead guilty, the court is not bound to follow the agreement of 3 years. I could give you any sentence that I felt was appropriate between 2 and 8 years, or community control, or whatever, fine you, whatever the law provides. You understand that?
Yes, sir.
Also, the matter of judicial release is up to the court, so the fact that the state agrees not to object does not guarantee that it will be granted. I'll still have to make that decision based upon whatever information is presented at that time. You understand?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
Now, you have certain constitutional rights you must understand before I can accept the plea. First, you have a right to have an attorney, and Mr. Armentrout was appointed to represent you. Now, his appointment wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you would like him to provide. So, if you decide you do not want to do this, that you want to defend against this case, he'll continue to represent you, defend you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Now, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those folks are selected, there would be a trial in which evidence would be presented, and they'd be instructed on the law by the judge. And then that jury would have to decide by a unanimous verdict, meaning all 12 would have to agree on whether the state proved your guilt. Now, if you didn't want to plead guilty, but you didn't want to have a jury trial, you can have what's called a court trial, which means the judge is the one that hears the evidence instead of a jury, applies the law, and decides whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Thompson, you have a right to confront witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney has the right to ask questions. That's called cross-examination. The purpose of that is trying to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, your request, court issues a court order, is called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Under the Constitution, you have a privilege against self-incrimination, Mr. Thompson. What that means is you can't be forced to give evidence or to testify at any time in the proceedings, including the trial. No one can ever make you testify. The prosecutor can't, the judge can. It's up to you, and if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, when you entered your plea of not guilty, that denied the allegation in the indictment, denied you committed any crime, and that exercised all those rights that I had just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegations, admit their crime, that you committed the crime, and that plea waives, gives up all the rights I've just explained for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty waives, gives up your right to a jury or a court trial. Waives, gives up your right to confront witnesses against you and to cross-examine them through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives, gives up your privilege against self-incrimination because you're the one saying you're guilty, that's what's used to find you guilty. It waives, gives up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty at trial. It also waives, gives up any right to file an appeal you think you could have had up until today in the proceedings. Now, if I were to sentence you to the maximum sentence or under other limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Thompson?
Yes, sir.
Now, you have any questions about the charge in count 4 or the possible penalties?
No, sir.
Do you understand those?
Yes, sir.
Have any questions about the plea agreement?
No,
Do you
sir.
understand it?
Yes, sir.
And you understand that the recommendation on sentence as well as on position of the state on judicial release is not binding on the court?
Yes, sir.
Have any questions about the constitutional rights I've explained?
No, sir.
Do you understand those?
Yes, sir.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No, sir.
Do you understand?
Yes,
Now,
sir.
is there anything you'd like to speak with your attorney about before we go any further? If you do, I can put you and him in the breakout room, and no one else will be able to see you or hear you.
No, sir.
All right, do you have any questions at all, Mr. Thompson?
No, sir.
Then is it your decision to withdraw your not guilty plea to count 4 and enter a plea of guilty to that count under the terms of this plea agreement that we've just gone over?
Yes, sir.
All right, then as to the charge in count 4, which does allege that on or about August 16, 2023, continuing through August 17, 2023 in Highland County, Ohio, that you and Cameron D. Renner did knowingly cause or attempt to cause serious physical harm to V by means of a deadly weapon or dangerous ordinance, to wit, a Taurus PT 140 40 caliber handgun, a violation of section 2903.11A2 of the Ohio Revised Code, charge of felonious assault carrying a possible penalty between 2 and 8 years is set by the judge. The possibility of any sentence imposed by the judge being extended by up to 1/2. On top of that, a fine of $15,000. How do you plead?
Guilty.
All right. Court finds that on this date, open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Please accept an order filed. Defendant is found guilty of the charge of count 4. Remaining counts are dismissed.
Your Honor, could I be heard for a moment?
Yes.
I realize we have an agreed upon sentencing here. I would ask the court to consider a sentencing date and to give him an OR bond so that he could take care of some stuff. He's been incarcerated since the beginning. I know the co-defendant was actually out on bond. He had posted a bond, but he did show up for his sentencing. I know where he would be living, and he's been no problems with me. He's been a fine young man. He got caught up in something that he shouldn't have here, and I would ask the court to consider that.
Mr. King, what's the position of the state?
The state would take no position on that request, Your Honor.
Does the defendant have any previous convictions?
He does not have any previous convictions that I'm aware of.
See, there's adjudication of delinquency in 2017 in Ross County.
I think that's all, Judge. It was in discovery.
Yes, that's all I'm aware of is a juvenile
Okay.
conviction, Your Honor.
Where would Mr. Thompson be going to?
It would be 21 South Pullman Road in Chillicothe. That's his mother, Your Honor.
Well, now, if I were to grant an OR bond, it's going to be under pretrial supervision, so he's going to be under house arrest the whole time, only with the exceptions of going that he can go to. So what are his plans while he's out if I were to release him?
I think the only thing, Your Honor, is he wanted to be able to see his grandfather, to be honest, but maybe Grandpa could come to see him.
And is he going to be living at their place, or will that be somewhere else?
No, Grandpa lives in Chillicothe, but at a different address.
All right. All right. Well, Mr. Thompson, what I'm going to do then, I'm going to allow you to be released on your OR, and this is unusual for me. Well, my general policy is if I sentence somebody, I don't release them from custody because we've had a lot of issues over the years with people not showing up for their sentences. And so what I did do now instead is I'm going to release you under the house arrest conditions. I'll allow you to see your grandparents.
Thank you.
But if you don't show up for sentencing, remember the recommendation on sentence is not binding. And so if you don't show up for sentencing, the chance of you getting the sentence that's been recommended may not be very good. It may be a lot more. Plus, you could also be charged with a new felony of failure to appear, which would be a 4-3 felony. Could be another 6 to 18 months on top of any sentence that you would be receiving in this case. You understand that?
Yes, sir.
All right. And you understand that other than there are certain exceptions I have already imposed upon you. I'm going to add the exception you can visit with your grandparents, but you got to go directly there and back home. And the only other thing you can do is if you've got to go to the probation department or to see your attorney or make a court appearance or something like that, medical issues, that's the only thing you can do. You understand?
Yes, sir.
All right.
Thank you, Your Honor.
All right. Well, I'll go ahead and put on a new bond order that says that. So you can be released here. We'll get it out there hopefully here in about. I'll get my assistant to come in and she may be already prepared because she usually watches this anyway. So it'll be the same conditions as the arraignment entry, except the additional condition as an exception to house arrest. Well, first of all, it'll be OR instead of the cash or property. And then secondly, the additional exception to the house arrest that you can visit with your grandparents. And if there should be a need for them to be hospitalized, you can also go to the hospital to be with them. But other than that, you're to be under house arrest at all times. Do you understand that?
Yes, sir.
All right. And so with that in mind, I think the court will set this for sentencing on April the 3rd at 9 a.m. and you're gonna have to sign the OR bond there at the jail before he can be released.
Yes, sir.
All right, and, is there anything further from council?
Yes,
There you
Your
go.
Honor. April 3rd, it's been scheduled for a long time. It's a half-day hearing in juvenile court. Could we do it in the afternoon, I wonder?
Yeah. We have pretrials that day, but how about 12:45?
That's fine, Judge.
All right, 12:45. And is to appear in person at the courthouse at that time, Mr. Thompson.
I will.
All right? Thank you. Do you hear that?
No, I keep getting phone calls.
Oh, okay. Well, he's going to be released on his OR with an additional exception to house arrest that he can visit. Mr. West, if you would unmute yourself on the screen there. There's a button down in the lower left-hand corner of the computer. It looks like a microphone. It probably is red with a slice through it. If you put your icon on it, it'll say unmute. Just click on it. I had to mute you because there was some background noise that was causing some interference. There we go. That's perfect. All right, case number 23CR212, State of Ohio versus Chelsea Marie West. You are Chelsea Marie West, appearing there on the screen that says Chelsea West. Are you Chelsea West? Can you hear me, Miss West?
Yes, sir.
Miss West, can you hear me, Miss West? All right, that's not working.
She's trying to respond, Your Honor. I don't
Yeah.
think
Yes, it's the connection.
No, there's a weak signal there on that end, apparently. It's jumping now. Can you hear me all right now, Miss West? Apparently not. All right. I'm going to go ahead.
Yes, sir.
Okay, well, there's a real problem here with the quality of this interchange, of the exchange. Did you hear everything I just said? All right. I'm going to go ahead and,
Yes.
Mr. King, if you would just come on over here. What we're going to do, I'm going to recess this hearing, and Ms. West, if you can hear me, or Mr. Kirk, if you could text, tell them to log out and log back in, and maybe that'll fix that. But if not, we're going to have to reschedule this.
Okay, I don't have any ability to text her because I'm not sure. I know which facility she's in, but I don't have a phone number for the specific location she's at.
Okay. Well,
Ms. West, were you able, if you can raise your hand if you heard the court's instruction to try to log in again?
she is in St. Lucy's.
Lucy's, okay.
Yeah. All right, Mr.
I'll see
West,
if we can
or
get a
Mr.
hold
King,
of
if you just come on up.
Here's,
Mr. King, if you just come on over and we'll do Mr. Cottrell.
Yes,
And
Your
then
Honor.
we'll see if we can get the technical difficulties worked out there with the connection there. So, Miss West, you need to tell your caseworker, if you can hear me, to log out and try to log back in, because you're not hearing me, and what little response I can hear from you is broken up, and your screen is freezing up and going constantly. So we need a new connection. And I'm going to do another case while you're doing that.
Record sheet.
All right, this is case number 23 CR 165, State of Ohio versus Shane Everett Cottrell. Appearing on behalf of the State of Ohio is Assistant Prosecutor King. Appearing on behalf of the defendant is Attorney Catherine Hapner of Hillsborough, Ohio. And you are Shane Everett Cottrell.
Yes, that's right.
Mr. Cottrell has entered a plea of guilty to aggravated possession of methamphetamine, third-degree felony. The matter was referred to the probation department for a pre-sentence investigation. I did receive a report from them, and have each of the attorneys received a summary?
State has, Your Honor.
I have, yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
All right, Ms. Hapner?
Thank you, Your Honor. We do ask that you follow the plea agreement. We would note that Mr. Cottrell did successfully complete his inpatient treatment at the Rulon Center. He'll be starting his IOP. He's got to finish the paperwork on that and get that started. My understanding is he's been having negative drug screens, so we believe that he has faced his issues, and he is facing them head on and handling them appropriately at this point in time. Thank you.
All right, Mr. Cottrell, is there anything you would like to say?
I know I messed up. I'm trying to do the right thing now.
All right, and where are you living now?
221 Paulson Hollow, Chillicothe.
And who do you live with there?
Dwight Witt.
Harvey?
Dwight Witt. It's a friend of mine.
Okay. And I did not have a chance to review this before this hearing. Are you employed?
Yes.
Where do you work?
The Clemens Company in Chillicothe, Ohio.
A what company?
Clemens Company. I'm a carpenter.
Oh, okay. All right. And is that a full-time job you're working?
Yes.
How much are you getting paid?
It's $20 an hour.
All right. And where are you going through your IOP at Ross County?
Yes.
Okay, well, through what agency? Southern Valley?
Yes.
All right. All right, it's ordered the court then that you be sentenced to a term of 3 years of community control in the supervision of probation department under the following conditions. You obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, and be truthful in all statements you make to the probation department about your community control. You're to keep them informed of your residence, place of employment at all times, may not change either without prior permission, may not leave the state of Ohio at any time without prior written permission, and if you do, you have to have that passed on you when you're out of state. You may not enter upon the grounds of any correctional facility, nor may you communicate or attempt to communicate with anyone who's an inmate in those facilities. Now, because of your conviction, you're prohibited under both federal and state law from purchasing, possessing, owning, or using, or having under your control a firearm, ammunition, or dangerous ordnance. And if you were to do that, you could be prosecuted under both federal and state law for felonies. Now, it's also a condition of the community control that you not have those items while you're under community control. You may not purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD oil, or kratom, or any variant or analog of any controlled substance that has an effect similar to those, or any instrument, device, or thing that may be used to administer drugs, prepare their administration, unless you have a lawful prescription, a copy of which must be provided within 24 hours of receipt. Failure to submit to drug testing when and as directed. You may not purchase, possess, use, or have under control any type of an alcoholic beverage, nor may be present in any places where it's sold or being consumed, even that may be otherwise lawful. The defendant, you shall not associate with anyone who is a co-defendant in this case, or any other person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless that's approved in writing by your supervising officer. That includes any family members that would fall within that definition, unless you were living with them immediately before the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another without written permission. You must report any conviction, arrest, citation, or charge of violating the law or any other contact with law enforcement not later than the next business day after that occurs. You must provide your supervising officer with financial information records or your ability to pay any fees, fines, or costs to be reviewed. If you're referred by the probation department for an evaluation or assessment for any other treatment, therapy, counseling, training, or educational programming, you'll submit to that. And if there's a recommendation for programming, you're to roll in and follow that during the period pendency of this action. You're to pay the court cost, and make payment arrangements to do that. Well, actually, I'm just going to make that for you. You're going to pay $100 a month. I mean $50 a month. Beginning May 1, 2024, and then you'll make a payment every month after that. You're to successfully complete, successfully complete your IOP through Southern Paint Valley Mental Health, and I'm abbreviating that as SPVHC in the entry, and any aftercare recommended. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you, used by you, or any proper places under your control where you're found at any time, any officer of the probation department. There'll be no fine, there'll be no driving suspension. Now, you're also going to pay the court cost as a substantive order. If you don't make payments on that, then the clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. And if that doesn't collect it, then the court can order you to do community service in this county and give you credit for each hour you worked at an hourly rate set by the court. Now, in the event that the probation department finds that you feels that you have not complied with the terms of this order, then they will file a written notice of that with the court. There will be a hearing. You'll get a copy of it. There'll be a hearing. You'll be entitled to have an attorney. And if the outcome of that is that you have failed to comply, then at that time the court will revoke your community control and then give you a prison sentence of between 9 and 36 months and fine you $10,000. And if that occurs due to the fact that you've been convicted of another offense while you're under probation in this case, then if you were sentenced to a prison term in that case, it could be ordered to be served consecutively to any sentence imposed in this case. If you end up serving a prison term upon completion of that term, it is possible that the adult parole authority may put you under post-release control supervision for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised by a parole officer in the terms they set, and if they determine during the period of time you're under supervision that you've not complied, they can return you to prison and make you serve an additional period of up to 9 months for any single violation, with a limit cap of half of the prison term that was imposed for all violations. However, if you are convicted of a new felony while under post-release control, then in addition to whatever sentence a judge in that new case can impose upon you, that judge could also sentence you for being convicted while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period post-release control, whichever is greater, and if that occurs, that has to be served consecutively to the sentence in the new case. All right, now that'll complete the case. So as soon as we're done here, you need to go down to the probation department and let them know you've been sentenced to community control. And then they'll transfer you over to the new conditions. So the house arrest and the pretrial supervision conditions are no more. It's the new conditions I just went over with you. They'll also give you a copy of that so that you'll be able to refer to that if you have any questions. All right, is there anything further, counsel?
No, Your Honor.
All right. Mr. Kirk, I'm going to speak with counsel here about another case for a minute, and I'll come back to you.
Okay, can we check real fast? Can you hear us?
We're ready now for Ms. West, I believe.
I'll get the form in your box.
Case number 23 CR 212, State of Ohio versus Chelsea Marie West. You are Chelsea Marie West, appearing there on the screen marked Chelsea West. You're muted now. If you can unmute, please. That's what started our problem. Can you hear me, Miss West? All right, you need to unmute yourself. There's a button down in the left-hand corner that is red and has a line through it.
Okay.
There we go. All right, thank you. All right. Ms. West, attorney, is Dennis Kirk of Hillsborough, Ohio. This hearing is being conducted by Zoom, and she's appearing from, what is it, St. Lucy's, I believe?
Yes.
All right,
Yes, sir.
and Mr. King, on behalf of the state, is present in the courtroom. Mr. Kirk, you and your client both in agreement that this matter can be conducted by Zoom other than an in-person hearing?
Yes, Your Honor.
And you're all right with that, Ms. West?
Yes, sir.
All right. Ms. West entered a plea of guilty to aggravated trafficking in methamphetamine, a third-degree felony under Section 2925.03A1, a third-degree felony.
Your Honor, should be a fourth-degree felony.
Oh, it is. Oh, the trafficking is, oh, okay, yes, it is a fourth-degree felony. I apologize. Yeah, okay.
Thank you, Your Honor.
I was looking at, I thought the F4 went with count 2, which would have meant that the other one would have been count 3, so it would have been third degree. All right. Aggravated trafficking in methamphetamine, a fourth-degree felony. The court did refer the matter for a pre-sentence report, and I have had that provided to me. And if each of the attorneys received a summary?
State has, Your Honor.
I'm aware of its contents, Your Honor.
All right. Anything from the state regarding the sentencing?
Only was contained in the plea agreement, Your Honor.
And let's see, is there restitution?
$20.
$20,
Restitution,
yeah.
$20, yes.
All right, Mr. Kirk, on behalf of the defendant.
Thank you, Your Honor. I would ask the court to follow the plea agreement. In this case, Ms. West went, I believe, in early February to the counseling center. I can say just seeing her on the screen today, an improvement visibly. I understand she's doing pretty well there and is where she needs to be right now because she was really struggling with drug addiction. So would ask the court, based upon the plea agreement and the fact she's done well in treatment, to grant community control and allow her to remain in treatment.
All right, Ms. West, is there anything you'd like to say?
Yes, sir.
And you're at the counseling center in St. Lucy's, correct?
Yes, sir.
All right. Well, it's a judgment order of the court then that you be sentenced to a term of 3 years of community control supervision under the probation department under the following conditions. First, you're to obey all laws of all jurisdictions. Conduct yourself in law-abiding manner at all times. You must report when and as directed. You must be truthful in all statements you make to the probation department regarding your sentencing or regarding supervision. You are to, by the way, I forgot, Mr. Kirk, you and your client are both agreeing to this matter being conducted by Zoom?
Yes,
I recover that?
you acquired that, yes.
I was writing at the time. I thought I did. All right.
Yes.
So you're to keep your supervising officer informed of your residence, place, of employment at all times, may not change either without prior permission. You must be honest and truthful in all statements you make to the probation department. You're not to leave the state of Ohio at any time without prior written permission. And I know you're right there across the river, but even if you go over for a day trip or something, you have to have a written pass with you before you go across there because we have an interstate compact to that effect. You may not enter upon the grounds of any correctional facility or communicate with anyone or attempt to communicate with anyone in a correctional facility without prior written permission. You may not, because of your conviction, you're not allowed under either federal or state law to possess, purchase, own, use, or have under your control any firearm, ammunition, or dangerous ordnance. If you do that, that could be a felony under both federal and state law. You're not permitted to have any of those things or any other weapons while you're under community control as a condition. You may not purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has effects similar to those or drugs of abuse, nor may you have an instrument, device, or thing that may be used to administer drugs or prepare their administration unless you have a lawful prescription, and if you do, you must provide that within 24 hours of receipt to your supervising officer. You're to submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any kind of alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if it is otherwise lawful. You're not to associate with anyone who is a co-defendant, if there was any, nor any other person who has in the past or could in the future can influence you to commit a criminal offense or violate these conditions. Again, unless you have a written approval from your supervising officer. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another without written permission. You are to report any contact with law enforcement or any arrest, citation, conviction, or other charges violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees or costs can be reviewed and restitution. If you are referred by the probation department for an evaluation or assessment for further type of programming or counseling or any type, you're to submit to that. If there's a recommendation that you undergo any further programming, you're required to do that and complete it successfully. You'll be required to pay the restitution of $20 in full through the victim witness escrow account, including any service fee that may be required, and that will need to be done by September 1st of this year. Now, you'll be required to successfully complete the substance use disorder, which is abbreviated SUD in your entry, and it's / mental health, because I think that's usually a component, and that's abbreviated as MH. So in your entry, it'll read successfully complete SUD / MH treatment and recommended aftercare. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search of your person, your vehicles, your residence, or any other property or place that's under your control or where you're found at any time, any officer of the probation department. Now, again, the substantive order is restitution of $20 through the Whan County Task Force, plus service fees to pay the restitution through the victim witness escrow account. You're also ordered to pay the court costs as a substantive order, and if you don't do that, it would be a violation of community control conditions, because you're supposed to make monthly payments. But if you don't, then the clerk can collect that through other means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then then the court could order you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have not complied with these conditions, they can return you to prison, or I'm sorry, they can file a written notice with the court, serve a copy on you, and then there would be a hearing. And at that hearing, you could be represented by an attorney. And if the outcome of that hearing was that you'd failed to comply, then at that time, you could be sentenced to a term of between 6 and 18 months and fined $5,000. If you're sentenced to a term of imprisonment, upon completion of that term, it is possible the adult parole authority may put you under post-release control, supervision by a parole officer for a period of up to 2 years. And if they did that and you violated those conditions, they could return you to prison to serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, the judge can also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
Now, this completes your case. You're no longer under pretrial supervision, but you do need to contact the probation department Monday. Let them know you've been sentenced to probation so they can change you over to new supervision conditions. Okay? All right. Thank you very much.
Thank you.